heterodoxy, legal heterodoxy in developing countries. And the idea behind this session was really just to create space to focus on legal issues and issues of comparative law that arise in countries that are not always the focus of these kinds of gatherings. And so we thought that in a lot of developing countries or countries that are not Western Europe or North America, let's say, there are interesting legal developments that deserve attention. And in part because they deviate from what are considered to be the orthodox approaches or have deviated from orthodox approaches. And so that was the idea behind the panel. I think the sort of details of how that plays out will come from the papers. So without any further ado, let me turn it over to Vic Khanna from the University of Michigan, who's going to be talking about shareholder agreements in India. So Vic, let's say 15 minutes or so. So over to you.
Thank you so much, Kevin, and thank you everyone for joining. I'm looking forward to this session. This was a lot of fun to actually prepare for, so thank you for inviting me. So as Kevin mentioned, I'll be talking about the curious case of shareholder agreements in India. I was attempting to be cool and borrow a movie title. I guess I got halfway there. All right, so I thought I'd give you a quick overview of what I hope to do in my 15 minutes here. Basically, we're exploring the legal treatment of shareholder agreements in India. I'll spend a minute or two just talking about what are shareholder agreements. They're basically contracts among shareholders, but they're different than the plain vanilla contract because they usually have implications for non-parties and the functioning of corporate property, which is why in a lot of countries, there are sometimes special rules for them, although they're generally enforced. In India, the legal treatment is a bit of a mixed bag and is something of a, in a state of flux. I've sort of categorized shareholder agreements into three broad categories. One is dealing with transfer restrictions, who can buy and sell the shares. This is actually in the most state of flux. Prior to maybe just about 10, 15 years ago, these could not be enforced unless you had placed them in the articles, the charter of the corporation. That is now beginning to change. Shareholder agreements dealing with, shareholders agreeing to vote for certain people on the board or dividing governance power generally are not enforceable. And shareholder agreements dealing with specific governance decisions like vetoing or something like that, those are enforceable. So you've got sort of all over the place things happening here. Should I be monitoring the chat or no?
Hi, Vic, it was me. I was just saying that you're still on the title page of your slide, so I don't know if that's on purpose.
That's odd. Okay, thank you for letting me know that. I will switch to the page view. Sometimes that's a little better. All right, can you see the overview slide now?
Yeah, absolutely.
Excellent. Okay, yes. Thank you so much for letting me know. I appreciate that. All right, so I'll also mention after discussing India's treatment is the basic comparative perspective. This is easy. They're basically enforceable in Delaware and most common law countries without too much of a headache. In India, the treatment is, as I said, in flux and a mixed bag. And of course, then I'm going to try to connect it to like, why is that? Or what might be some potential explanations for it? And what I basically will suggest is that although, shareholder agreements might be thought of as being special because they affect third parties so often, that doesn't generally stop their enforcement in other places. So why in India has it been difficult to enforce these? And what I'm going to suggest is there are a couple of unique factors to India that make these difficult to enforce, at least traditionally. Originally, most shareholder agreements were between families, family business groups. That's because the vast majority of companies, both in the past and now, whether private or public in India, are actually owned through something called the Hindu undivided family structure. It is a way of owning property, and it's a governance structure that is pretty much unique in the world, at least at the moment. I think in history, there may have been things that were comparable, but as of now, it's pretty unusual. Because of that, that it's an unusual property structure, and because there are a lot of side deals that go on, courts are typically very reluctant, I think, to enforce shareholder agreements unless they're in plain view of everybody. And that makes them sort of push towards putting them in the articles. Well, why are things beginning to change? That's because the identity of the parties who are doing shareholder agreements is changing. With the rise of globalization and India's sort of rise in it, Private equity funds have been much more active in the Indian space and are much more active investing there. And as a result, you have a compositional change from who's actually in the shareholder agreement. Not as many families, more of the shareholder agreements. Where are the families going? They're actually opting towards trusts and settlements. And that raises a third point, which is, why is trust law in India incredibly accommodating? It is by far one of the most freewheeling contract freedom-based trust laws you're going to see. And one of the puzzles is, why would that be so freewheeling, but the shareholder agreements be so restrictive? And hopefully we'll try to get a little insights on those as we go through this. Okay, so if this is familiar to all of you, you can sort of imagine something more entertaining. Basically, shareholder agreements, as I mentioned, are between shareholders. They can include the firm as a party. They're becoming much more common as markets globalize, primarily because of private equity investment, but other reasons too. They cover a wide range of matters, transfer restrictions, board positions, specific voting decisions. One thing to note about shareholder agreements is there's a tendency in the literature, to the extent there is much of a literature, to look at them individually. Like, okay, here's a transfer restriction, let's think about that. Here's a board governance restriction, let's think about that. When in reality, they actually interact. That is, a shareholder agreement that deals with board powers and positions, when combined with a transfer restriction, is effectively a governance change, because that means it's going to be very hard for you to change that if a shareholder dies or leaves, because it's now sort of wound up together like that. Indeed, one of the interesting questions that's not specific to the comparative side, but just generally, is how far can you let shareholder agreements go? Would you allow them to undermine things that are in the charter and the bylaws? And that, I think, is actually an interesting corporate law question. In any case, in many countries, especially in India, they often involve family members and founders, and that can complicate the matters. All right, so that's sort of a little bit of a background. Why might you treat them differently? Because typically shareholder agreements end up binding or affecting non-parties to the agreement. And that's canonically the reason why you might be more skeptical of them. But in fact, that hasn't really led to greater skepticism. And we can talk a little bit about that if people are interested. Okay, India. So in India, transfer restrictions are where you've seen the most change. There's an important Supreme Court case in 1992 called V.B. Rangaraj. You'll be examined on that by the end of this session. Their shareholder agreements here on transfers are not binding unless they're in the Articles of Incorporation. Many scholars have noted that that particular provision that they're relying upon was not intended to block shareholder agreements on transfers. It was designed to prevent board members from impeding transfer of shares. Similarly, in public firms in India, there have been cases that basically said that you're not going to be able to put restrictions on shares in publicly traded firms. But now, again, people have been noticing, wait, the historical reason for this prohibition had to do with restraining the board, not shareholders. And now we've seen a switch in 2013. Now, shareholder agreements in public companies are enforceable, although in private companies, it's still kind of all over the place. A big sea change occurred in 2002, where the Supreme Court in the Kerala Commodity case decided that if a shareholder agreement doesn't bind future shareholders and deals only with specific shares, not all of them, then there'll be no actual prohibition to them being enforced. Although this decision kind of went unheralded when it came out, it was incredibly important because almost as soon as this happened, a year later, you saw private equity funds pushing hard to have shareholder agreements in Indian sort of investment contracts. There's been a lot of regulation in this space too in India that has sort of allowed future transfers like tag-along rights, drag-along rights, all of that to be permitted, but that's been by regulatory fiat, not by judicial case law. That state of flux in contrast to the position on what happens if a shareholder agreement tries to determine board powers. Here, the answer is pretty simple. No, you can't do it. And it's interesting, typically the reasoning behind this is, if you want to encumber the power of directors, you need to do that in a way that's visible to all the shareholders, because then they understand that they can't rely on the directors to do what they normally think directors could do. It's sort of like an expectations model, let's say. There are a couple of cases I mentioned here. Basically, they're all sort of going the same direction. All right, and then you have shareholder agreements on specific decisions. These are generally enforceable, and typically they have less of a governance impact than, say, the board-related shareholder agreements. For example, you may not be able to encumber a director's power via a shareholder agreement, but you can enforce voting agreements and even entrenchment agreements in some ways, which is intriguing. There are also sort of side agreements like with the promoters and non-competes, but the general gist of this is the lesser the governance impact, the more likely it is it will be enforced. Okay, how does this compare to Delaware and other common law countries? So in Delaware, common law shareholder agreements are basically enforceable. It doesn't really depend whether they're in the articles or not. It doesn't really matter if the firm is a contract party, it just determines who they can enforce it against. And they can cover a lot of things. There's essentially no restriction, it seems. A recent study looks at shareholder agreements in publicly traded firms in the US, and they find the following, that they're pretty common. They occur in somewhere between 1/6 to 1/5 of firms. They cover a lot of things that you might not actually able to be doing in the charter or the bylaws, especially director appointments. And we see that there's quite a lot of them that deal with transfer restrictions, mandating arbitration between shareholders in the company, et cetera, et cetera. So the sort of the overall picture here is that amongst common law countries, India is by far more restrictive than any of the other common law countries. And I don't know enough about the civil law jurisdictions, but I'm going to venture a guess that India's approach is perhaps a little restrictive there too. Why is that, right? So there are lots of potential explanations. The one that I mentioned in the paper, but I'm going to dispose of quickly here, is the notion that shareholder agreements are special. I think they are in terms of, they're an unusual kind of a contract, but they're special everywhere. It's not different across countries that way. I think what is distinct about India is the fact that early on, most of the companies that had shareholder agreements and were basically run by family business groups. And in India, that means that a lot of things are happening that courts might be worried about. So to just preface this a little bit, the Indian context allows for an unusual property ownership structure under something called their personal laws. So those of you who are familiar with India, you can, again, imagine something more entertaining. But basically in India, the laws that govern your inheritance and your marital matters are determined by your religion, unless you specifically opt out. So basically the only people who opt out are Bollywood stars. So most people basically marry within their religion and they're subject to their religious codes. Now, why is that relevant for shareholder agreements? Well, it's because basically if you're a Hindu, which the way they define it would cover about 90% of the population, you can own property in something called a Hindu undivided family. It is a form of joint tenancy that allows property to be basically held in the family unit. And as a result, it means that you can't sell it without unanimous approval of the family. But short of selling, typically the oldest patriarch gets to decide what to do and is essentially not subject to judicial review. It's a very unusual setup where you have kind of autarkic fiduciary duties in some ways. But the bottom line basically is that because of the Hindu undivided family structure, it means that there's a very strong incentive for there to be a lot of side deals and a lot of oral deals. And I suspect that one of the reasons why Indian courts have traditionally been very reluctant to enforce shareholder agreements has been because they're aware of this background. I mean, just to give you a sense of the scale, approximately 85% of the land in India is owned by Hindu undivided families. And approximately 95% of publicly traded companies are owned by various Hindu undivided families. The other 5% are owned by the government or by non-Hindus. So that gives you a rough sense as to what the extent of how common these are. As a result, I think the courts look at these and they understand that if we're just trying to enforce an agreement, there's a very good shot that we won't really understand what we're enforcing because there's so much happening outside of the purview of the contract. And as a result, if you want to enforce it, they insist that it be in the Articles of Association, which not only forces disclosure, but it also means it can't be changed easily without board and shareholder approval. And I suspect it's in some respects a counterbalance to that. One of the reasons that I suspect that is we're seeing a change at the same time as the composition of shareholder agreements in India is switching, right? We're seeing now in the last 10 years, most shareholder agreements are not involving family businesses, they're involving private equity. And here, of course, the concerns are much less that there's going to be something going on outside of the context of the contract as much. I mean, there might be something, but not as a general matter. And so you can sort of see the dynamics beginning to switch. Also, private equity pushes hard for arbitration, mainly because they don't want to deal with the delays in the Indian court and the perceptions that they're not very expert. The other thing that's happened is, again, a compositional effect. Hindu undivided families are increasingly trying to manage their affairs not through shareholder agreements, but through trusts and settlements and what are called family constitutions. And one of the questions that's most intriguing is if you look at Indian trust law, it's all willing to allow you to do all kinds of contractual things that I would say English and American trust law don't allow you to do. As a result, a lot of families find that if they want extra contractual flexibility, they might actually prefer to go to the trust structure, which is kind of intriguing. Why would the courts be willing to sort of allow for broader interpretations in the trust context? I suspect the reason is that when you form a trust, you are implicitly busting up the Hindu undivided family. You are taking property out of that structure and putting it into a trust. Now you can put a Hindu undivided family around a trust, right? But that requires an additional step. First, you break up the Hindu undivided family, you put the assets in the trust, and then you'd have to recreate a Hindu undivided family around it. That makes it actually, I think, not as attractive to create the second stage Hindu undivided family around it. People push to the trust, and they find that the flexibility of contract there allows them to replicate some of the things they might like in the Huff structure, but be able to do it in the trust structure too. And that makes it kind of interesting. The other thing, of course, is when you have a trust, you have to self-identify that you're a trust. And so people know there's a trust, whereas with a shareholder agreement, unless it's in the articles, you basically don't have a clue. All right. So I'm trying to make sure I stay within my time here, Kevin, so do let me know if I'm getting close. 2 more minutes, perfect. Just long enough for the conclusion slide, perfect. So as I mentioned here, shareholder agreements, of course, cover a lot of different things. The regulation in India is very much a mixed bag. It's in a state of flux. It's different than in other common law jurisdictions. And my sense is that the explanation for that is not because shareholder agreements are somehow that different than other contracts. They are. That just doesn't justify different treatment across countries because they're different everywhere. What's different in India, I think, is the fact that most of these were between family in the context of a Hindu undivided family property ownership structure, which makes it much more likely that you've got other things going on and that the exact property implications of how these agreements work is actually much more messed up. Ever since I wrote a paper on the Hindu undivided family about 2 years ago, it's nuts how many calls I've gotten from people about how do you resolve a Hindu undivided family issue. Not my intent, but it's been interesting. Apparently there are Hindu undivided families or people who believe they're in a Hindu undivided family throughout the United States and in England and in many other countries who believe they're operating under this structure that most jurisdictions outside of India would not really know how to recognize exactly. Anyway, I think as the Hindu undivided family has moved away from shareholder agreements and towards trusts, and as private equity has moved into the shareholder agreement space, we're beginning to see movement in terms of how the courts treat it. But now that they're moving towards the trust, I think you're going to see more and more of that, partially because the trust allows you to keep your agreements in place after the members change, which a shareholder agreement doesn't because they're personal, whereas the trust is an institutional structure on its own. All of that to basically say that to the extent that one is thinking that contract enforcement is consistent across countries, India is a good example for where it's not, but also where it's under a considerable degree of flux and change for reasons that are somewhat idiosyncratic to the Indian environment. And with that, I think I have 26 seconds left. Are we doing questions right after, or?
I think we'll wait. So we'll do all of the papers sequentially and then take questions, in part because I suspect the papers will speak to one another. That's my hunch because I know a bit about the paper that we're going to talk about next, which is the one that I've co-authored with Mariana Pargendler, who's going to present it together with me. One thing we didn't decide on though, Mariana, was whether you would be sharing the slides or I would be. I think if you're starting, it might be easier if you do it, but I also have them here, so we can do it either way. Oh, and you're still on mute, by the way.
I just wanted to make sure I have the right version, but I think I do, so I'm sharing them right now. Okay, I'll begin presenting our paper on contract law and inequality. So I begin by saying a few words about the conventional wisdom with respect to comparative contract law. So there's this general idea that contract laws don't differ much around the world. Specifically, there is there are the well-known civil versus common law distinctions, which are thought to be eroding over time. That's the general sense. And in particular, there is no suggestion of systematic differences between developed and developing countries with respect to the substance of contract laws. There is a large literature on contract institutions suggesting that there are major differences in enforcement in developing countries, which of course makes a difference economically, but the studies by institutional economists, they measure only enforcement, the time and the duration of the enforcement process, which in fact is in marked contrast to what they do in other fields. When they study corporate law, they actually measure corporate law, but when they measure contract institutions, they only measure enforcement. So this project aims to show that there are actually differences in the substance of contract laws of developing countries, and that make them distinctly heterodox. Heterodox is not supposed to be positive or pejorative. It's supposed to be different from what is perhaps the norm or thought to be the norm in developed countries, or even the norm in the books, on the books in developing countries themselves. So we define heterodoxy as the overt attempts to achieve distributional objectives through contract adjudication, such as tackling inequality and protecting disadvantaged groups. And we pursue this project through case studies of South Africa, Brazil, and Colombia. So before Kevin begins by, Kevin continues the exposition, I just want to say a few words about some caveats. We're not claiming that contract law heterodoxy prevails in all developing countries, and not even that it prevails across the board in developing countries, only that there are differences and that they are more heterodox than the laws of developed countries. And this is important because we're also suggesting that the distinction between orthodoxy and heterodoxy is best understood as a continuum rather than a strict dichotomy. We also do not claim that heterodoxy is effective in achieving its intended distributional objectives, and we take no strong normative stance regarding the merits of contract law heterodoxy. But we do say that contract law heterodoxy is likely to be consequential from an economic standpoint, and therefore deserves further examination.
Great. So let me kick things off just by emphasizing what we're not talking about, or what our examples are diverging from, which is what we take to be the orthodox approach to contract law. And it's basically that contract law is concerned with a bunch of values, is potentially concerned with a variety of values: autonomy, efficiency, or equality in exchange, depending on your favorite contract theorist. But it's not concerned with achieving distributional objectives. And we think that the orthodox view, and I think this certainly reflects the orthodox view amongst law and economics types in the United States, but perhaps more broadly as well, is that to the extent you're interested in achieving redistribution, it should be accomplished through fiscal policy, so taxes and spending policy, as opposed to through contract law or, in fact, any other branch of private law. And there are two main justifications for that position, for that preference for fiscal policy as a means of redistribution. First, it's more legitimate. So it's just not the business of unelected judges to be deciding on redistribution of wealth. It's actually something for democratically elected representatives. And this is something that you'll see in Rawls and so forth. And then secondly, and I think independently, there's a concern about effectiveness, that the tax and transfer system is just better for achieving these ends. It's more accurate and predictable because judges have limited information, say about the wealth or the number of dependents of people, so they can't actually do a good job of figuring out who to take from and who to give to. The tax system is obviously more comprehensive, so if necessary, it can cover everyone, not just the parties to the contract. There's less of a distortion associated with taxation in some circumstances. This is sort of double distortion argument that, I won't go into the details of it, but I think many of you are familiar with it. A more common concern, and probably the most salient concern for a lot of people in relation to the idea of using contract law for distributional purposes, is that parties can avoid it. If you start forcing people to offer better terms to say poor people, well, they'll either stop contracting with the poor people or find another way to change the terms of the contract to basically achieve the same distributional outcome. And then finally, there's the concern about interdependence. So for instance, if you have a rule that targets, that redistributes from corporations to their consumers, well, certainly in countries like the United States, there's a concern that if you target corporations, you're actually targeting a lot of pension plans and individuals who will then be disadvantaged. So it's harder to do, to achieve redistribution through contract law for all of those reasons, and better to do it through fiscal policy. So maybe if we'll quickly now talk about what we see that's different in developing countries. And I'll start things off by talking about South Africa, which I guess is on the next slide. So what's interesting about South Africa is that there's a commitment to the idea that, at least in post-apartheid South Africa, a commitment to the idea that contract law has to conform to constitutional values, right? Those include the values of equality and some of the positive socioeconomic rights that are set out in the Constitution, and also a concept known as Ubuntu, which is an African concept that emphasizes the communal nature of society, humaneness, social justice, fairness, solidarity, and all sorts of other good things, right? Now, individual contractual provisions are not subject to constitutional scrutiny. It's more the idea that constitutional doctrines are subject to constitutional scrutiny. And there have been several cases of the several decisions of the Constitutional Court of South Africa that have taken that idea quite seriously and have really tried to use contract law to achieve what we think of as distributional objectives. So one of the leading examples is a case called Paulson and Slipknot, where they changed the rules on whether prejudgment interest could continue to run after the initiation of litigation, and they said that it couldn't. And the reason was quite explicitly that they cared about the position of debtors, and there was a sense that debtors were actually more vulnerable in general in South Africa than creditors. So I think I have a quote that comes up next on the next slide, where it where we talk about, where we just quote from the decision. So let's see, Mariana, if you can roll it forward a bit. Right, so this was from the case on the prejudgment interest, where they just start generalizing about the debtors, saying that they're likely to be disadvantaged by the significant disparities that you see in South Africa. And this doctrine, this change in doctrine, was motivated in part by the need to reverse some of the inequalities that were created by the legacy of apartheid. So that was one example. The next example, I think maybe next slide, was a case involving a land real estate purchase agreement, where the idea was to basically grant more favorable remedies to a purchaser who had actually defaulted on their payments, but still, prepaid for a while and wanted to be reinstated so they could actually acquire the land. And even several years later, they changed the rule and they changed the remedy and allowed the purchaser to get the land, which again was motivated by concern for the plight of purchasers of real estate on installment contracts, who tend to be, on average, the poorer members of South African society. One thing to notice is that this doesn't always work. And there's a case that was decided just this year where the court set out the limits on this doctrine, so that it doesn't apply to the actual contractual provisions, where they refused to say that failure to renew a franchise agreement for the benefit of a set of Black businessmen was necessarily a constitutional violation. And in the interest of time, I'll skip over this case. But they sort of were very concerned about the idea that if they treated this as a violation of equality rights, then that would discourage parties from contracting with disadvantaged Black businessmen and would sort of undermine the purposes of the regime that had been put in place to protect them. So with that, I'll stop and turn it over to Mariana to talk about developments in Brazil and Colombia.
So we see a similar pattern of resort to constitutional values and horizontal effects of constitutional provisions in contract adjudication in both countries. So in Brazil, there is significant incidence of distributional rhetoric and contract disputes, including appeal to solidarity, social justice, human dignity, and the social function of contract. There is perception of greater legitimacy of appeals to such social justice. So when there are famous surveys of judges in Brazil, and most of them believe that they state when in a survey that they believe that contracts should not be enforced if that would violate the requirements of social justice. And there are various examples of situations that Brazilian law seems to deviate from what would be orthodox contract law rules. So one central area concerns the very economically important scenario of the purchase of housing. In Brazil, it's very common for consumers to purchase new housing while it's still being constructed, and that is paid in installments that actually help finance the construction of the project. So courts have awarded strong exit rights to consumers in these circumstances by effectively allowing them to terminate the contract at will. Of course, the evolution was more subtle. Some of the cases initially took very much into account the precise circumstance of the consumer that had lost a job or had a health problem. So those were some frustration or impracticability doctrines attached to it. But eventually, case law settled so as to permit consumers to back out of those deals, subject to the payment of judicial fine. That's how I would functionally characterize it, of 10 to 15% of the amounts paid. So consumers could essentially receive back 90% of what they had paid for housing, making essentially that, giving them essentially an option in that respect. Also in the housing contract context and also beyond, courts have applied a doctrine of symmetric penalty clauses. So that says that if, for instance, in the housing context, it's very common if there is a penalty imposed on the consumer for late payments. The very same penalty should apply for any delays by the construction company. Also, in the context of insurance contracts, courts have appealed to the social function of contracts to invalidate various restrictions to coverage, even in cases in which they were expressly permitted by statute. There has been some backlash against this, what is called the civil/constitutional law, which is the constitutionalization of civil law, and what is thought to be excessive state intervention in contract law. So Brazil enacted a new law on economic freedom that in many ways aims to restate contract law orthodoxy by saying things such as rewriting of contracts should be exceptional. And even though there is this recent backlash, which just goes to show the prevalence of previous heterodoxy, this is very recent. It's a 2019 statute under the current right-wing administration. It's so noteworthy that it's not meant to cover consumer contracts. And even the strong presumption against judicial rewriting of contracts that now is present in the new statute only apply to paritary and symmetrical contracts between merchants, meaning that even this backlash would still allow for rewriting of contracts between merchants that are not thought to be symmetrical. You see also a lot of heterodoxy in Colombia, and many cases decided by Colombia's constitutional court. So there's consistent appeal by this court to the right of the vital minimum, health, human dignity, and inequality explicitly in adjudicating contract disputes. So those are invoked to restrict insurance companies in their ability to terminate insurance contracts despite what would be otherwise a result under orthodox contract law principles, also in providing for the narrow interpretation of insurance of coverage exclusions when the parties to be affected are particularly vulnerable, and also to provide for the continued provision of water in view of the particular economic circumstances of the consumer in questions, despite the lack of payment for the service, for this essential service. We also explain why would it be that we see what seems to be greater heterodoxy in developing countries. And we posit that that relates to significant inequality in those countries, together with the failure of the fiscal system in tackle inequality in a significant way, and that lends legitimacy to contract law responses to this problem. So basically, it's the opposite of the conventional law and economics view that pushes, of course, these issues of inequality to the tax and transfer system. However, if those are not being addressed by the tax and transfer system, and inequality seems to be such a pressing problem, we posit that there appears to be greater legitimacy in the use of contract law to tackle those issues. We also discuss the limits of contract law heterodoxy. One theme that appears and it is a classic comparative law theme is the possibility of functional convergence, and that can take different forms. So perhaps some of those cases would be decided exactly the same way, and what we are seeing are more differences in reasoning or differences in arguments, and but rather than differences in results. And we think this is true for some of our cases, but not for all of them. We also think we are also seeing beyond heterodox legal doctrines, heterodox results, different results. But another possibility in terms of convergence is that some of the problems here are addressed not through contract law, but perhaps through other areas of law, so that perhaps in the US, bankruptcy law would be more amenable to distributional considerations or concerns that in other countries are tackled through contract law. We also explore the the lack of comprehensiveness and avoidance, which are conventional critiques of heterodoxy that Kevin has mentioned, but in particular how they would interact with the peculiar circumstances of developing countries. One prediction of the economic literature is that if contract enforcement is costly, you might have greater vertical integration. But how appealing is that in the context of developing countries whose economies are already dominated by large business groups that could, of course, also enhance business groups' positions as parties with well-established reputations. So we also, beyond the conventional critiques, we also explore limits to the normative appeal of contract law heterodoxy, given the particular institutional conditions of these developing countries. We also explore prospects for convergence, or if you will, reverse convergence, that is convergence towards heterodoxy becoming more orthodox. And we do address cases of horizontal effects and contract relations in continental Europe. So some of them have some heterodox flavor, although it is possible to reinterpret them as consistent with orthodoxy. So Europe, continental Europe, perhaps along the spectrum, is slightly more orthodox than US contract law, but less so than the developing countries that we study. We also discussed some of the closer cases of heterodoxy under US law, including famous cases on unconscionability and how contract law can operate as part of a response of the law of the poor. And we also explore briefly, but some legal reforms that have been enacted recently in response to the COVID-19 pandemic. And here I would just note how the German statute in connection with the emergency made the availability of remedies specifically contingent on the ability of the person affected to provide for their family or not. So both creditors and debtor rights were contingent on that specific circumstance, which is one way to take into account distributional concerns, but that is markedly distinct from inequality in exchange as a fairly orthodox consideration. So we are noting here innovations in contract laws of developing countries. So the story we are telling here, and maybe in this context, it might be different from the Khanna story with respect to shareholder agreements. We're not talking about some particular or ancient features of the laws of those countries that have persisted, but rather new doctrines that have emerged in perhaps the last decades. And we believe there are lessons for contract theorists about how much some of the conventional wisdom might be dependent on the particular institutional environment, also for law and development scholars, be heterodoxy desirable or not. It's certainly noteworthy and likely to have economic implications, as mentioned before, which of course also affects the life and advice of practitioners in those countries in ways that cannot easily be found out by just reading the books.
Thank you. So next, we've got Taisu Zhang. So let's see, I think, Taisu, yes, you're a co-host as well. So you can, if you've got slides, you can share them. If not.
Right. I think you guys have to stop sharing first before I can share.
Right. Great. So Taisu, Yale Law School, talking about the history of corporate law from a very different perspective. So Taisu, take it away.
All right, thank you. So thank you to Kevin and Mariana for organizing this panel. I'm looking forward to the discussion greatly. And all right, so this is a paper that I'm co-authoring with my colleague John Morley, who cannot be here and sends its regrets today. It turned out that this PowerPoint is way too long. I didn't really pay attention while I was driving it up. So I'll skip over some slides while I do this. So the motivation doesn't really matter. The central question that we want to really address is this question of basically, like, why does the business corporation emerge so late in human history? And by business corporation, we mean a legal entity, and not necessarily the kind of like general phenomenon of like large-scale business collaboration between strangers that will actually play a role in the explanation. But what we want to explain, following this relatively large literature that's currently still being played out amongst economists and lawyers, is the rise of a certain kind of legal technology, pretty much in the 18th and 19th centuries, after the creation of the English and Dutch East India companies. And this legal technology basically is a business firm that has the following characteristics. It has a separate legal personality from its shareholders. It has collective governance structures, joint stock equity finance, transferable shares, lock-in of investment, but most importantly, it has what we call asset partitioning, which is entity shielding plus limited liability. First-order characteristics actually existed in great abundance in all kinds of pre-modern firms, actually ranging all the way back to the Roman Empire in some cases, and in the Chinese case to something like the 6th or 7th century AD. Asset partitioning is a modern phenomenon. At least asset partitioning in the context of business firms that go beyond kind of like single voyage merchants collaborations is a modern phenomenon. Like in the context of firms that do business over the long term, that engage in like long-term repeated interaction between its partners or investors, asset partitioning basically begins to. I don't know what you mean by. I'm sorry, like my Siri thought that I was talking to her. Asset partitioning basically exists as a modern phenomenon, and this is like relatively well established in the pre-existing literature. We're not the first to make this observation. People like Ron Harris, Guiseta Dari Matiachi, and many others have made the similar, Timur Kuran and so on and so forth have made kind of like a similar observation. But the question is why, right? So the concept of asset partitioning was actually known to pre-modern business actors in many contexts. So things relatively well-known medieval forms like the commenda, which is like a relatively widely used kind of corporation in Italian city-states. It's kind of like a modern corporation, except that it only exists for a single voyage, and it dissolves upon the termination of a voyage. So basically, what happens is you have a bundle of goods, you enter into a firm, I guess, with a merchant who is traveling to some other part of the Mediterranean. You guys sign an agreement that you kind of share ownership in this firm, and in both cases, your liability is limited to what you invest in the firm. At the same time, there's also entity shielding that shields the firm from your personal liabilities. So the commenda has asset partitioning, but again, it's a single voyage entity. And you see these single voyage entities across the early modern world in many places. You see them around the Mediterraneon, around the around the Indian Sea. You see them in China in certain kinds of like joint family firms and so on and so forth. Nonetheless, nearly every single one of these was in the context of basically these like one-off interactions between partners. Like it was just not used. This technology, even though it was known, was not used with any kind of apparent economic significance in the context of like more sustained long-term collaboration between business partners. And we want to ask the question why that's the case. It's not, especially given that people have conceived of this technology, it's not quite obvious why it doesn't become kind of like a widespread economic phenomenon that's used by kind of like more long-term business collaborations until something like the 18th, 19th centuries. So the pre-existing literature on this comes in largely two varieties. There are demand-side accounts Ron Harris, 2020, Guido Darimati and his co-authors, 2017, Avner Greif and Ty Bellini in 2017, Tim Guinan, Naomi Lamaru, and Shayla Ogilvy, I think, had a 2007 paper that basically made kind of a similar argument. That argues that, like asset partitioning used in this kind of like long-term collaboration context really arises only in response to demand side factors that are largely characteristic of modern economies, but not so much of pre-modern economies. And this is the core demand side account. The core demand side factor that I identify is the rise of like large-scale interregional trade and kind of global commercialization in the 17th and 18th centuries, which begins to produce pressure for these kinds of like more secure and kind of like less risky forms of investment. Then there are supply side accounts that kind of draw from this like Doug North-ish kind of insight, which basically says, no one will invest in these kinds of modern corporations until the governing entity over the jurisdiction can make a credible commitment towards not expropriating. So obviously these demand side accounts and supply side accounts are not mutually exclusive, and many recent accounts, including Ron Harris and Guisep and his co-authors, have made both of these. There are some gaps in this literature. All right, so first of all, the demand side conditions need to be laid out in a bit more theoretically kind of abstract terms, given the fact that modern corporations now exist in large numbers outside of the context of long distance trade. So long distance trade may have been the original context in which these things arose, but what you want is a theoretical account of what is it about long distance trade that creates these demands, and why are these demand side factors also existent in more modern contexts that have nothing to do with long distance trade. But more importantly for our purposes, and this is the core argument of our paper, these accounts portray the state's role in this entire narrative in a much too negative fashion. Basically, they think the state's role is to not expropriate. We think there is a much more positive role the state plays, and we want to basically illustrate and identify that. And to kind of motivate why we think there has to be another factor thrown into this account, consider the Chinese counterexample in the early 20th century. So in 1903, the late Qing state, in kind of like the last decade of its existence, introduces a modern corporate law that's basically designed according to German and English principles, which basically introduces all the elements of modern corporations. After it was introduced, there basically was no use of this corporate form until pretty much the 1930s and 40s, and really not until like the 1970s, actually until the late 1970s and early 1980s, after China's post-Mao opening up reforms, did kind of modern corporations become a major economic phenomenon in China. But at least in the 3 decades after the legal technology was attempted to be introduced into the economy by these legislatures, there was basically no use. That said, the demand side conditions identified by our preexisting literature quite clearly existed in this early 20th century context, and that there was tons of long distance trade and global trade happening amongst Chinese businesses. For whatever reason, even after the states tried to push the use of modern corporations, people didn't use it. Now, was the problem that the pre-modern Chinese states couldn't make a credible, it was too exploitative, it couldn't make credible commitments? Well, that's not true either, because the state at this point in time was so incredibly weak that it was completely credible when it said that we wouldn't expropriate corporate assets, because even if it actually had wanted to expropriate corporate assets, for the most part, it didn't really have the administrative capacity to actually do so. So, China from like 1900 to kind of like 1930, or even before that, is an example of a situation in which both the supply side and the demand side factors in the current literature existed quite strongly, but modern corporate forms did not emerge. And not only did they not emerge, but even after the state tried to introduce the legal technology, no one took them up on it until the 1930s. And so there's a question that you have to ask, why was this? So these are our goals. We're going to skip this. So the core argument basically is twofold, but mainly it's on the supply side. On the demand side, like we do some work in trying to distill down the kind of demand side factors that this literature on foreign trade and global trade is really getting at. So we basically argue that modern business corporations emerged in response to demand for these factors: collaboration between large numbers of strangers who share residual claimant status over a business that engages in what we call thick economic activity. And by thick, we mean economic activity that's kind of contingent and kind of dense enough to not really be able to float, that kind of escapes the capacity of a priori planning by contract. So this is the theory of the firm stuff, right? So contexts in which you have to engage, you have to use firms instead of just contracts to organize our activities. But the more important argument that we want to pose is that modern states contributed positively to corporate development by supplying the legal and administrative infrastructure necessary to enforce incorporation and investment agreements. So much so that the rise of modern corporations actually depended and continues to depend on the existence of what we call modern state building. And what we mean by this is, it means that you have like relatively strong, professionalized, administratively capable modern states that also manage to create professionalized judicial systems with strong informational and enforcement capacities, right? So, court systems that are capable of gathering lots of information and also enforcing relatively complicated legal agreements between people who otherwise share no social relations. So a different kind of motivation that's actually quite critical to this to the model is that consider the alternatives to the modern state, right? Like what are other entities in human history that have been able to kind of enforce either legal systems or systems of rules that basically functionally are equivalent to legal systems. These are of two kinds, right? Like one is the kind of like the social norms literature that Bob Ellickson and many others, Richard McAdams and so on and so forth, were pioneering in the 1990s, which basically argues that in close-knit communities where everyone knows each other, you can pretty much have the same kind of like rule enforcement power that you see in modern legal systems, that you see in states, right? And in these kinds of close-knit communities, the belief is that they can enforce just about any kind of sophisticated rule-based arrangement. They can enforce property rights, contracts, torts, pretty much anything you can think of. Now, that said, but if you look at the kinds of rules that existed in these like early modern tight, close-knit communities, lineages in the Chinese context, yes, family firms and family community, like close-knit village communities in the Mediterranean and so on and so forth. They have many things that you see in modern states, modern legal systems. They have contract law, tort laws, property law, and so on and so forth. But they don't really have corporate law. They have business firms, but the firms basically are partnerships in the sense that for the most part, there was no formal asset partitioning between the firm and its investors. And so this begs the question, why is this, right? You might think that, it's because these close-knit communities lack the ability to enforce corporate charters or things like that. But that doesn't seem to be true, right? Because if you believe the social norms literature, in the close-knit community context, they're pretty much capable of enforcing anything they want, given that everyone knows each other and trusts each other, and you can have really complex reputational mechanisms that allows for very sophisticated legal enforcement. So why don't you see the modern corporation existing, or something functionally equivalent to the modern corporation existing in these contexts?
Taisu, just so you know, we maybe just a few more minutes,
right,
so we have some time
right,
for questions.
Right. So I'm gonna actually the framing actually sets this up, sets the argument up relatively nicely. So our argument basically is twofold. We basically want to argue that essentially, in these until the modern world, in these like early modern well, actually in any kind of close-knit community, you don't like it's not that they weren't capable of enforcing the modern corporate form. It's actually that there was no demand. And the reason for this is, if you think about what something like asset partitioning actually does, is that basically it shifts risk away from investors and from the firm itself onto creditors. So it basically lowers the cost and risk of investment at the cost of higher borrowing costs. But that only means that tends to mean that the modern corporation is only attractive. A corporation with asset partitioning is only attractive in a context where the risk to investors is relatively high. So if you're within a closely knit community in which everyone knows each other and trusts each other, then pretty much you don't have any need for the business corporation, because the risks involved in investing and in these kinds of joint enterprises and collaborations is relatively low to begin with. So why would you want to take on the cost of like higher borrowing costs just to kind of lower the risk of investment when the risk of investment was already quite low in the first place? So because of that, but our argument basically is that from the demand side, in this kind of to use the Weberian terminology, in this kind of like mine shaft context where everyone is relational and knows each other, you don't have any demand for these kinds of things. They only become attractive in contexts where people don't know each other, and you want to do kind of complicated, sophisticated, thick and dense business collaborations with lots of strangers. Now, in that context, however, then like I think most of us would find it intuitive that when you're doing when you're engaging in a really thick, sophisticated, contingency-filled collaboration with large numbers of strangers, then that's exactly the context in which enforcement of rules by communities, or even something like the law merchant, which is basically kind of like a network of communities interacting with each other in terms of rules through arbitrators. None of that is sufficient anymore. Instead, you need a centralized entity that has the coercive power, that has the administrative muscle to enforce these kinds of corporate charters across large numbers of stranger investors. And one final thing is that, especially in the corporate context, given that everyone's a resident claimant, there's a huge need to make a credible commitment to all the investors that the rule enforcing entity, i.e., you can call it the state or the courts or whatever, is able to enforce the corporate charter and the obligations and duties and rights of all these investors in a fair manner. Right? Like you have to guarantee them treatments according. You have to guarantee them equitable treatment according to basically how much stock they own. And this is something that both the law merchant and in some ways these kind of close-knit communities struggle to do vis-a-vis outsiders, right? So if I'm a stranger going into a different community than my own, and I'm collaborating with someone in that community, and assuming that his community is the jurisdiction under which we're going to enforce our collaboration agreement, then how would that community persuade me that they can guarantee me fair treatment? So I would basically have to know somebody in that community that could serve as an intermediary. But that is, for all kinds of reasons, is very costly and makes these kinds of arrangements unable to sustain thick kinds of business collaborations. So basically, from that point of view, one of the benefits of the modern state is that not only do they have the administrative muscle and do they have the kind of powers of enforcement that you need to enforce these kinds of corporate charters vis-a-vis strangers, And the corresponding point to that is, frankly, these kinds of corporate charters with asset partitioning are only attractive in the context of doing business with strangers. But also, especially when you're doing business with strangers, there's this especially high need to guarantee potential investors that everyone's going to be treated equally by the law enforcement apparatus. And the fact that modern states, in some ways, like are more distant from the business community, that they have more checks and balances, that in many ways, they are in the Northian context able to make credible commitments of self-constraint and institutionalization of their power. They are actually able to make this kind of credible commitments to all parties much more readily than any kind of like privatized village or lineage or some kind of a kinship group or a guild of closely related collaborators. And so for both of those reasons, we come to the conclusion that basically you're not going to see the widespread use and embrace and adoption of the modern corporate form with asset partitioning until you see the rise of the modern state. And insofar as the modern state is a relatively recent phenomenon, in virtually every single context, English, German, French, Japanese, Ottoman, Chinese, Indian, and so on and so forth, the rise of these like modern corporations with asset partitioning comes after the rise of the modern state. Now, that point in time varies from country to country. In England, it's something like, starting from the mid-17th century. In the Netherlands, it arguably was even earlier than that, and still like building up from the 17th century to the 18th century and so on and so forth. In Germany, it probably came with like the rise of the Prussian Empire in the kind of like mid-19th century. In China, it was really not until the 1930s or 40s that you began to even have like a semblance of a modern state. And that's when you begin to see the corporate form being used. In the Ottoman context, we cited Timur Kuran and some other people who basically argue that it was like after 1878 and into the early 19th century that you actually see the rise of modern corporation pretty much synchronized in step with modern state building efforts by the late Ottoman state. So with that, I look forward to the questions. Thank you.
Thank you very much. So you can ask questions by raising hands, and let's start with Franklin Gewertz.
Right, thank you. And let me say I appreciated all the papers. I'm gonna have the question, however, for the last one. It's a shame we weren't on the same panel since I was my presentation dealt with corporate history and the development of various attributes and so on. It's involved, maybe we'll need to talk offline, but it seems to me that one pushback and challenge is that you focus on one of many attributes in the corporation when you talk about asset partitioning. In fact, there's two attributes there. Limited liability comes late. It only arrives in California in 1931. We've been an organized state before that, we like to think. And so it's not necessarily critical. As far as the other half, the ability to have ownership by an entity, that goes back to almost Roman times in early European history for non-business entities, which were able to hold property. So that exists. What often then becomes the other attribute that is the name used for countries outside the United States for a business corporation is this joint stock company, and so on, which features the attribute of transferable shares of ownership. There may be an overlap with respect to that, although one was able to have in England joint stock companies formed that weren't actually legally formed corporations. They simply put the property they needed in a trust form, but they still had the transferable shares. I guess your thesis then is it necessary in order to have free transferable shares that there be a modern state? Maybe, not sure the difference in the modern state between the Dutch, where this all develops in 1600 and change, and states that existed elsewhere before that. you can also do large-scale enterprises without transferable shares, and that the feudal Japan was built around the house system, and there were quite large companies that were operated within the family structure of that. So I guess that's kind of my pushback on the top of my head, and what's a very interesting thesis you developed. But as I say, it seems to me that because you get into asset partitioning as opposed to transferable shares, and I'm not sure in that instance whether maybe transferable shares would be clearer with your thesis, maybe it wouldn't. So that's my opening question there, perhaps not as well formed as it should have been. And
Taisu?
backlighting.
All right, great. So thank you for the question. I think the most basic answer is that, so asset partitioning, the way that we understand it is pretty much, we take this term from Ron Harris and Henry Hansman. Basically, it means two things, right? You're right, it means more than one thing. It's limited liability plus entity shielding. Now, that's not quite the same thing as separate legal personalities, right? So you're completely right. Separate legal personalities has an incredibly long history. Across human history, it exists pretty much like virtually everywhere, likely before the birth of Christ. That said, asset partitioning, in the terms of like entity shielding, is a relatively modern phenomenon, right? So you know, even back in the day when you had separate legal entities, that didn't mean that the corporation or the firm that you were creating was shielded from the debts of its owners, right? Like, you know, Roman courts readily allow creditors to reach into the firm's assets when enforcing a debt claim against one of the firm's owners. So that kind of like formal financial separation between the two things, we think, and we basically just follow the literature on this, is a 18th, 19th, and in some cases even 20th century phenomenon, which arises largely at the same time as limited liability. So that would be the answer.
Thanks, Virginia.
Yeah, thank you. I had a question for Taisu. Also really enjoyed this paper. Actually enjoyed all of the papers. It's great to see all of you even remotely. So just want to say that this has been really fun to listen in on. I had a number of questions similar to Frank but just briefly, one question I had, and this may be something that you mentioned already, is already in the project, but it strikes me that it might be helpful to consider what are the role of possible substitutes in terms of bearing risk that relates to, you know, again, high risk, high investment types of projects that would be entered into by relative strangers, or at least by some interactions that don't involve people you already know. And I would be very curious, it seems like you say that these types of corporate structures that are good at this, you know, the equivalent of the multinational even, would not emerge until, you know, the modern era. But I wonder to what extent, again, the imperial system and even funding by the emperor, or backing or guarantees or insurance, the equivalent of insurance guaranteed by the imperial state, whether that's through a local representative or really through Beijing and the coffers of the emperor, might substitute for a kind of guarantee or an enforcement mechanism. And were there ventures that were on the scale of the, you know, East India companies? I know sailing ventures from the mainland by, you know, kind of famous seafaring heroes, and wonder if maybe that is an exception, or maybe that's an alternative model, how widespread the role of the empire was in that regard in substituting for what otherwise would be these kind of legal mechanisms. So that's just something that I'd be curious about. And since your project touches on such a wide swath of history, I think that would be particularly interesting. But I share Frank's questions with regard to kind of the two dimensions of the asset partitioning piece. So I'll just kind of add a thumbs up for that.
Right. So thank you. Basically, like, to the extent the state gets involved in anything, then we would say it kind of actually fits into our thesis. Like we want to basically make the argument that this kind of like long-term investment between large numbers of strangers isn't really possible until something like the state, with the state's coercive powers and ability to guarantee and backstop certain kinds of assets, gets involved. In the Chinese context, I'm not quite sure it actually exists in the Qing, largely for the reason that, I mean, like, the Qing is an incredibly weak state, fiscally and financially. So that's actually like what I'm currently writing my second book on. You know, compared to modern states tax, what, 35% of their GDP to 50% in the higher end. You know, early modern states range from something like 5% in the Ottoman context, in the Ottoman Empire context, like 8 in the Russian context, like 15 in the Japanese context, like 20 in the English context. The Qing state taxed nominally 1% of GDP for most of its existence. Now, a state like that doesn't really have much of an ability to basically finance long distance trade of any kind. I think what you're referring to more is like the Ming Zhenghe voyages and so on and so forth, but that's not a state financed like business investment. That was like a military campaign with an entire basically army plus navy traveling with traveling along the voyage. But you know, if that counts, then too, we've been struggling with this question of like whether we should count, you know, like basically state ventures as corporations. If we do, I mean, then that would actually fit into the thesis quite well, because the states are already involved directly in a very robust way in those kinds of things.
Great. Peter Wright.
Hi, I'm trying to get my video here. Hold on. Oh, okay, there we are. All great papers, really deep dives into subjects which I personally don't know very much about, although the subject I know the most about is contracts, because I've taught it. So I actually had a question for Professor Davis and Pargendler. If you're looking at judicial policing of contract inequality through different types of arguments across, you know, various countries, can you make a generalization about what's most effective? So in the United States, most contract policing is done through internal doctrines like unconscionability, right? But in Europe and Latin America, more constitutional arguments are used. I mean, is there some sense of, is it all country specific, or is there some broader generalization about what's most effective when you look at cases that have engaged in policing of contractual inequality?
Well, I'd say that we're not at the stage yet where we feel comfortable saying anything about effectiveness, but we would draw a distinction between what I understand US doctrine on unconscionability to be doing and what we see happening in some of these other jurisdictions. Because as I understand US unconscionability doctrine, it's about to the extent it's about inequality and so forth, it's about addressing inequality as between the two parties, right? Inequality of bargaining power, the sort of transactional inequality. Whereas here we're talking about cases that seem to be trying to address social inequality, where the party who is disadvantaged not just in relation to their counterparty, but also in the context of the society as a whole. And the courts are consciously talking about that kind of social disadvantage. So those Black businessmen who are not just, you know, disadvantaged relative to the person they're dealing with, but in society as a whole. And so that's the distinction. We don't see that in the US.
Right.
But I think the main response to your question is we're just not comfortable talking about effectiveness yet at all.
The reason I asked is because the US unconscionability doctrine a lot of it was developed with these DC Circuit cases by Skelly Wright, where you really were talking about societal inequality. Frost and Fries versus Reynoso, I mean, the inequality of bargaining was simply a reflection of the fact that there was predatory sales of appliances in poor neighborhoods and neighborhoods of people of color. So in other words, that distinction necessarily with unconscionability doesn't always work. In other words, I think Skelly Wright was getting at societal inequality through the medium of transactional inequality.
We think that's exactly right, although I think the more contemporary understanding about unconscionability doctrine has moved away from the idea of the unconscionability as a tool and as part of the law of the poor. So we do talk about that, and also suggest maybe there will be a resurgence of interest in that aspect of US law, but that's at the back end of the paper. But thanks, yes, so I think we're on the same page.
Thank you.
So next, Zara, and I'm conscious of the fact that we're running short on time. So maybe we should take a couple, maybe the next 3 questions just to make sure that we get them in. So Zara, and then Vic was actually trying to raise his hand, but as a co-host he can't, and then Francesca. So we'll take all 3 questions and then have the responses.
Okay, thank you so much. So I just want to first introduce myself. I'm a teaching fellow at Harvard Law School and also a lecturer. I'm also writing about unconscionability doctrine and public policy, so I was really interested to hear your take on it. So I have 2 questions. Is your, I'm sorry if I don't know this, but is your paper already like a draft that you've shared, or were we only seeing the slides now? Because I would be really interested in reading when it comes out or when it's in a format that you're comfortable sharing it.
Well, let me just say the conference didn't provide a facility for sharing papers as we understand it, but if you maybe write to, I'm sure all of us will be willing to share whatever we have. We do have a draft that we should be able, that we're willing to share, but I can't speak for Taisu and Vic.
So I'm going to be real quick because I know other people have questions too. So from what I've studied, I think that there has been a way that courts in the US don't want to get involved into private contracts as much as they can, and unconscionability has been pushed away so far behind that they're trying to, they would only get involved in cases where they think, you know, it's really shocking the conscience, which rarely happens anymore. Whereas in outside of the US, public policy arguments, which I think you framed it in a way that it's kind of constitutionalized. Mariana mentioned how in Brazil it has had pushback, but correct me if I'm wrong, that the public policy defense that we also can use even in contracts in the US seems to be not adequately used as much as we see it outside of the US, that, you know, in terms of how constitutional law is just driving this agenda in contract law. I would just be curious to know if you think the public policy defense in the US and the way that we use it in contract law is similar to the way that we see contract law being a force for good outside of the US. Thank you so much.
Vic, thanks.
Thanks. So very much enjoyed the papers. I had just a couple of quick thoughts. One was Kevin and Mariana. It strikes me that you might expect to see a lot more of the activities of the courts in areas where you might expect to see the greatest degree of inequality, let's say in employment context. So speaking, for example, from the Indian context, it's very common to see courts being unwilling to enforce non-compete clauses. They basically flatly refuse to do it. It's caused all sorts of interesting questions because a lot of tech-related companies, when they go to India, want to sign non-competes, they sign them, and then the court just basically says, we're not going to enforce it. And the primary reason for that is they think that you can't, the basic reason is in a country where there was so much inequality, they simply did not think it was worthwhile to allow people to restrict your employment opportunities any further than the ambient environment already did. Taisu, on your paper, so I had a couple of thoughts. One is, you may already be familiar with this, but there's an interesting book by Morris Silver on when civilization arises. And it's sort of like in the Ellickson mold in terms of how he thinks about it. But it struck me as interesting because to the extent that you're premising the growth of the corporate form as you're defining it on the rise of the state, then that sort of kicks the question back as to why does the state rise? And naturally then you get into this kind of recursive loop that can drive you nuts. But in essence, it pushes you back to why you might want civilization. And that's an interesting book. It has some interesting insights that build upon, or at least are consistent with some of the things you were saying in your presentation, more specifically to the corporate context. So I think that you may want to very carefully delineate the different features of the corporation. There's actually quite a lot of evidence, not just of what you might call, either state-run corporations in Roman times and so forth, but even privately run entities that lasted for generations, that were more than single voyage journeys, dating from approximately 600 BC onwards. I can provide you with some materials on that if that might be of interest. What's interesting is that their rise and fall does tend to correlate with various kinds of state attributes. So that would be consistent with your broader thesis, although what that suggests to me is that certain features may be correlated with certain types of state structures and others with others. I suspect that the asset partitioning is something that you do actually see even in the private context, going back to about the 5th century BC. So that predates a lot of state structures, although not all of them. And it might be interesting because it might help to sort of hone in on the question of what attributes of the state are actually important or sort of go well with the corporate structure as we think of it in modern terms. It may be that you have functional states, well-functioning states early on in time, but they're missing certain features that the modern state has that allows the business corporation as we see it today to sort of grow and thrive. So that instead of it being a story of the state, sort of pushing forward corporate forms, it may well be the case that there's a symbiotic relationship here where there are features of both that actually gel well together and that you needed both to actually get to a particular stage. But I can send you some stuff if you're interested.
Thanks. And Francesca.
Very quick observation question for Kevin and Mariana, which is that you talk about the alternative to contracts being fiscal policy, but regulatory law, of course, also deals with inequality of the parties. And some countries do regulatory law in so many different ways. And so some places you have extensive regulation of employment contracts, obviously. You have extensive regulation of consumer contracts, utilities, etc., and it's not classic contract law. And so the question is how one deals with that variation in trying to make these cross-country comparisons.
Thanks. Let me just take the privilege of the moderator, I guess, to ask a question for Vic, and then we'll get to the answers, hopefully in the 2 minutes that will remain, which is I just was wondering about not the comparison not to Delaware and the US in general, but to countries where you have more closely held or family corporations, because it seemed to me that would be the most natural comparison. And so I was wondering, because then the main difference I take it would be the Hindu undivided family, but it seemed to me there'd be lots of complicated issues going in any complicated family enterprise. So that was my question for you. And Taisu, this may be just for as the project develops, but I'd be very interested in which industries or which sectors you think this type of, the sort of, the state is most important. So where is it that, which sectors sort of manifest the thickest forms of contracting? Okay, so with that, we've got a couple of minutes for answers. Mariana, do you want to answer the questions that were about, I guess, our paper?
Muted.
Okay. So as to Zara's question, which in some ways also relates to Peter's earlier question, and because I don't think I would have answered exactly in the same way Kevin has, and we've had many discussions about how to characterize the unconscionability cases, which were finally characterized as belonging to the orthodoxy. Although I think there is, that is a little bit less clear, because I think that perhaps a country's willingness to engage with unconscionability doctrine or related doctrines in this type of context, such as kind of the incidence that you suggested, might place countries along this spectrum. So I think this is that's interesting as well, not only in terms of the rhetoric the courts uses, but the incidence. They do it a lot. In Brazil, they do it a lot. You know, you needed a new law to say this is exceptional, and between merchants, make sure that the merchants are in unequal position. This is what the extreme right-wing government managed to do, you know, and no way, of course, consumers are completely out of this economic freedom statute. So I tend to see it that way, although in the current version of the paper, you know, we characterize unconscionability as completely consistent with the orthodoxy, but perhaps there can be some nuance. I certainly tend to see it that way. I mean, Vic, with respect to employment agreements, that we have a caveat at the beginning of the paper that we're not dealing with employment agreements. And with that, we are dramatically understating the degree of contract law heterodoxy in developing countries. I mean, don't even get me started under Brazilian law. And the reason we are not doing it is because I think there is some value in treating contract law as excluding contractual agreements as a separate strand of the literature as it is usually thought. And also because there is more literature, in fact, on employment protections and in developing countries compared to developed countries. So I think that that part of the argument is less original, but I think insofar as the same, it is helpful insofar as I believe the same factors that push the type of heterodoxy that we see in contract law certainly exactly. So I think your point is absolutely correct, and in fact I think it is consistent, of course, with our argument.
I'll just point out we're out of time. I don't know if we get cut off somehow, so I just wanted to acknowledge that. Hopefully we can stay for another minute or so, but I don't know if Sherry, who's also on this call, will tell us. But yes, apparently we can continue. So I'll just answer the last couple of minutes, because Taisu also had a question.
Great. So Francesca, I think that's absolutely right. And in fact, the first version of this paper was called Contract Law, State Capacity and Inequality, because we also think that because I think the inequality component is one dimension of contract law heterodoxy more generally in developing countries, and deficiencies in the regulatory apparatus also explain other differences that we see. And eventually we excluded that part because it's probably another paper for various reasons, but I think that's very much deficiencies in the regulatory state, certainly a major source of legal heterodoxy in developing countries. And I've done some work on corporate law that suggests precisely that. So we hope to explore this in the future.
And actually, I forgot, there was also a question for Vic, I believe. So Vic, did you want to respond in a minute, and then Taisu?
Sure, I'll be quick. So yeah, I actually, initially the reason I focused on common law countries was I figured if I held the legal family constant, that might be interesting. I did actually take a peek at other countries that have what you call, sort of smaller corporate structures. They typically aren't that different compared to Delaware, which is interesting. There's some degree of difference. Some countries require registration of shareholder agreements. Most don't. So that sort of element of making it public is present in some places, but it's not like required across the board in civil law countries or even in countries that have small companies. And even when the US didn't have the behemoths it has today, and same with England, they didn't actually require shareholder agreements to be registered or to be made in the articles. So that in that respect, India is something of an outlier, but I suspect that perhaps in a lot of countries, maybe throughout, I don't know about the rest of Asia, but I wouldn't be surprised to see some kind of registration requirement as a minimum. But I don't know if that would be limited to just companies that are held by family.
Right. And the last word goes to Taisu.
Vic, thank you very much for those questions. Let's chat a bit more by email afterwards, because I actually love to see the sources. So basically, like, I think you're exactly onto the core arguments of the paper, which is really like, we don't care so much about the history. What we care about is the functionality. Like we care about there being this synchronization between basically three things. We care about there being the following three things being somewhat synchronized: the state, or some kind of state capacity, large-scale businesses that involve large-scale collaboration between strangers, and then finally the corporate form, right? So if all of those things were synchronized in some kind of fashion in pre-modern or like prehistoric or in ancient history, and it's certainly quite plausible, because like pre-moderns, like ancient states often had state capacities that are far, far beyond what you actually saw in the early modern world. I guess the question there is, do you also see the kind of like the doing business with strangers aspects? Because in the Roman Empire, like most literature suggests that you rarely dealt, you certainly had long-term business collaborations, but you didn't do that much with people that you weren't closely related to. So I guess like, so the real question is like in more distant history, are those things still synchronized or not? And I'd love to kind of read more about this. Like the current literature, like Ron Harris's new book, especially, and then Henry Hansman, some of his earlier work and some of these other articles, seems to kind of like suggest, or at least it gives off a narrative to say that at least like those things are kind of like a post, pretty much like 1800 phenomenon from most of the world. But again, like honestly, like they could very well be missing something, because none of these guys actually are in any sense like classicists or know much about like the kind of ancient world. So I'd love to know more. Thank you.
Great. Well, thank you everyone for joining us. This has been certainly tremendously helpful for me, and it's tremendously stimulating as well. I've learned a lot. And so with that, have a good evening, and hopefully see you at the rest of the conference.
Thank you.